Thank you so much for joining us for the 2024 Hardt Cup Finals. My name is Margaret Krusner. I'm the president of the Moot Court Board, and I'm thrilled that this lovely event will be the last thing I will do as that role. I'd like to say thank you so much to the Hardt Cup coordinators who put on an amazing competition for 76 first-year students who opted in. So thank you to Maggie Ash, Brandon Bishop, Miranda Campbell-Kerrigan, and Rachel Gu, as well as the Moot Court Intramural Chair, Megna Melcote. I'd also like to give a brief congratulations to the first-year students who made the Moot Court Board through the competition. We've got 26 excellent new additions to the Moot Court Board, and all their names can be found in the program today. Two amazing competitors who also made the Moot Court Board will be competing in the final round today, so I'd like to briefly introduce them to you. First, we have Casey Byrne, who will be representing the Petitioner, the Board of Parole hearing. Casey is a first-year student from Arlington, Virginia. She graduated from the University of Notre Dame in 2020. Before law school, she worked as a paralegal for the DOJ Fraud Division. Casey's the incoming president of the Women's Law Students Association, and she's also a member of the Mock Trial Board. Next, I'll introduce William Allred. He'll be representing the Respondent, Omar Sharrieff Gay. William is also a first-year student. He's from Plano, Texas. He graduated from the United States Naval Academy in 2018 and served in the Marine Corps Infantry until 2023. At Duke, he's an ACLU 1L rep, and he participates in the International Human Rights Pro Bono Project. Now, these two are arguing before three fantastic Duke alumni who are all part of state and federal judiciary. There's full bios available also in the program, but just to briefly introduce them, we'll be seeing the Honorable Sarah K. Campbell. She's a justice on the Tennessee Supreme Court, and she graduated from Duke Law in 2009. Next, you'll meet the Honorable Robin Rosenberg. She's a judge on the United States District Court for the Southern District of Florida, and she graduated both from the School of Law and with her master's in public policy. And then you'll meet the Honorable Mary Scriven. She's a United States District Court judge for the Middle District of Florida, so we've got lots of Florida represented if you're from there. Should be exciting. And she graduated from Duke undergrad and received her JD from Florida State University. Now, you'll hear a case today with a brief summary, but I'd just like to give you a little bit more information so you can contextualize our advocates' full arguments. Today's case is about parole eligibility interviews. So Omar Sharrieff Gay, who will be represented by Will, he's an inmate in the custody of the California Department of Corrections and Rehabilitation. The psychologist employed by the Board of Parole hearings, represented by Casey, reviewed Mr. Gay's file, interviewed Mr. Gay, and employed risk assessment tools by mental health professionals to prepare a comprehensive risk assessment report to submit for his parole suitability hearing. Now, their report found that Mr. Gay posed a high risk for future violence, but Mr. Gay brought a civil rights suit alleging that he was racially and religiously biased in the questions and in the psychological evaluation. He claimed that the psychologists were prejudiced against him as an African-American Muslim man, which influenced their conclusion that Mr. Gay was a high risk of future violence. The psychologists argued that they are actually immune from suit under a doctrine called absolute immunity because they performed a discretionary function that was integral to the Board of Parole hearings' quasi-judicial decision-making. So the question that our advocates will be arguing about today is whether the parole hearing psychologists who prepare these comprehensive risk analyses are entitled to absolute immunity. This case is a fictional appeal of the Ninth Circuit's decision in Gay versus Board, and you can find that decision in real life. But without further ado, please congratulate our finalists, and we'll welcome in the judges.
All rise. Oyez, oyez. All persons having business before this honorable court, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God bless the United States, and God bless this court.
Good afternoon, counsel. Are we ready to proceed?
Yes, Your Honor. Petitioner is ready. Good afternoon, Your Honors, and may it please the court. My name is Casey Byrne, and today I am counsel for petitioners Amy Parsons and Gregory Goldstein. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
So noted.
This is a case about protecting functionality and discretion amongst parole boards. This court should reverse the Ninth Circuit's decision and hold that psychologists are absolutely immune for the discretionary functions they perform integral to the parole process for 3 main reasons. The first, psychologists here function to help adjudicate rights. Second, psychologists exercise discretion in making these decisions. And third, we should ensure they are not impaired by exposure to potential damages liability. First,
Counsel, do you believe that in the context of the work that they do, their role as non-decision makers should play in the court's consideration of what immunity they're entitled to?
Your Honor, we actually believe that psychologists here are decision makers. The psychologists here evaluate the prisoners, they interview them, and then they decide what risk the prisoners are to future violence.
My understanding of the record is that the psychologist expressly acknowledged that he was not a decision maker, was not making decisions, but was making recommendations to the court on behalf of the Parole Commission and at the direction of the court. How do you square your analysis with that concession?
Yes, Your Honor is right that the psychologist's evaluation is not binding on the parole board's decision, but they are a decision maker in what level of future violent risk they believe the prisoner has. We don't believe the fact that the psychologist's evaluation is not binding on the court. We don't believe that to be fatal to the petitioner's claim.
So back to my original question, you do not believe that it's necessary for the court to find that they are the decision maker in the outcome of the case in order to establish entitlement to absolute immunity?
Correct, Your Honor. We believe they still meet the functionality approach laid out by this court in Antoine. If this court had wanted to only give absolute immunity to binding decisions, this court could have made that clear. However, this court has granted absolute immunity to prosecutors in initiating a case and for their presentation of that case. That is not binding. A judge's decision is appealable and can be overturned. So we don't believe the fact that the psychologist's risk assessment is not binding on the court to be fatal here. As this court—
Are there situations where a parole board psychologist would not be entitled to absolute immunity? And if so, what scenario would you suggest?
Yes, Your Honor. Here, the psychologist's role in their evaluation of the prisoner is directly tied to the parole board's evaluation. The psychologists here are employed by the parole board only to make this risk assessment. We have no evidence that the parole board reviews anything outside of the psychologist's report. So in that way, psychologists' work here is directly tied to the adjudication of rights, which is what Antoine requires. To the extent psychologists are merely providing a general evaluation and not making any risk assessment decisions, they may not be entitled to absolute immunity. But here—
If I could interrupt for a moment. So we have distinguished, and lower courts have distinguished between investigative functions and decision-making functions. This, to me, seems very investigative in nature. Can you explain to me why that is not the case?
Yes, Your Honor. Here, psychologists are not going on a fact-finding mission. The evidence has been collected.
What was the purpose of the interview if it wasn't to investigate in some way?
Your Honor, the purpose of the interview is to evaluate the prisoner and assess what level of violent risk they have. So it's not a fact-finding mission. These aren't police officers on the street. It is an interview, but they're using their experience, their education, their mental health risk assessment to evaluate the prisoner and using their discretionary judgments decide what level of violent risk the inmate would pose if released.
There are all sorts of discretionary decisions that are made in the course of a police officer's investigation. So what about this investigation actually distinguishes it from the sorts of investigations that we in lower courts have held do not qualify for absolute immunity?
Yes, Your Honor. The difference here is that psychologists' work is directly tied to the adjudication of rights. Police officers, when conducting interviews on the street, there are still many steps between that interview and the resolving of a dispute or the adjudication of rights, which is what the Antoine case requires.
Antoine is a case that I might suggest is wrongly decided. The notion that a court reporter would enjoy the same level of immunity as the judge for whom he or she reports. And because I can think of any number of functions that people serve supporting the court. The IT guy supports the court, it's essential to the function. The guy who turns on the electricity, if one of those people steps outside of the bounds of whatever they were doing and cause injury to a litigant, are you suggesting that we should give them qualified immunity or absolute immunity because they serve functional roles for the court that are essential?
No, Your Honor. We agree with Antoine's finding that even though the court reporter provides a function necessary to the court reporter exercised no discretion there. The court reporter's job was to create a verbatim transcript. So the court reporters in Antoine failed to establish absolute immunity because they exercised no discretion. Here, psychologists exercise immense discretion in what level of risk they assign the inmate, but also in what questions they ask of the inmate during their evaluation. And so the psychologists here are both key to the adjudication of rights, but they also exercise discretion similar to that of a judge in making a decision.
Why wouldn't qualified immunity be sufficient to protect their interest in inappropriate litigation against them in the course of their work?
Yes, Your Honor. As this court has found, there are some functions that we think deserving of absolute immunity because of the tough discretionary decisions that officials have to make. Here, psychologists may be evaluating an inmate that's in prison for rape or for hate crimes. Questions of race and gender may come up, and we want to empower the psychologists to feel comfortable asking those tough questions, making those tough risk assessments without any fear of potential litigation. If a psychologist labels an inmate as having a high risk of violence and that inmate's parole is denied, after spending hours or days being evaluated by that psychologist, that inmate goes back to their cell with the psychologist's face in his mind. We believe Respondent would agree that the parole board is entitled to absolute immunity, making the psychologist the next line of defense if that prisoner is unhappy with the parole board's ruling. Because of the discretion and the functionality that psychologists use here,
I'm sorry to interrupt. If the report included the interview and background information and kind of an evaluation, but came short of actually making the risk assessment, what would your position be? I mean, is it that it all comes down to this high risk, low risk, or is it broader than that?
Yes, Your Honor. We believe that the high risk, low risk evaluation is directly tied to the adjudication of the prisoner's rights, and that's what entitles the psychologist to absolute immunity. The psychologists here are employed by the parole board only to make that risk assessment, which the parole board then uses to decide whether an inmate should be paroled. So while not actually binding, we believe it to be functionally binding in that if the parole board receives that report and it says that an inmate has a high risk of violence, the parole board is going to take that under advisement and not let that inmate out.
Do you think that, go ahead.
I can't think of anyone whose face is more prominently featured in the mind of an incarcerated individual than the officer who exercised the discretion to detain them in the first place and offered up the charges. And officers are protected by qualified immunity in virtually every aspect of what they do. And so why is a psychologist analysis entitled to greater protection than the on the beat, in the moment law enforcement officers?
Yes, Your Honor. We believe that psychologists meet the Antoine test threshold of entitling them to absolute immunity because of how close their function is to the adjudication of that prisoner's rights. When officers are interviewing or arresting someone, there's still a long process before that defendant's rights are adjudicated. Here, the psychologist acts as an arm of the parole board in assessing the inmate and of the adjudication of that inmate's rights. And as this court has held, there are some functions that we hold so important and discretionary. We believe that those functions should be performed with absolute immunity so that there is no fear of potential litigation clouding someone's judgment. If a psychologist is interviewing or evaluating an inmate and has concern that asking questions of race or gender or any potentially sensitive subject could lead to litigation, it may cloud their judgment on what risk level they should assign that inmate.
But qualified immunity is a doctrine that's intended to protect against that risk. Qualified immunity is designed to ensure that police officers' conduct is not chilled. So why isn't qualified immunity sufficient to guard against the risk that you just discussed?
Yes, Your Honor, it's not sufficient. Qualified immunity is a much lengthier and subjective process of determining whether an official should be given it. And we think that fear of potential litigation over the psychologist could have a chilling effect if they are not given absolute immunity. We think
What about the balance of the interest of the litigant and their right to have their day in court if they are affected by, in this case as alleged, racist comments by psychologists in the course of doing what they were called to do?
Yes, Your Honor, we don't see, if absolute immunity is given, we don't see there as being no recourse for the prisoner. They are able to appeal, they are able to reapply for parole, they can be re-evaluated by a psychologist. So we don't see absolute immunity as providing no recourse for the prisoner. And for those reasons, we ask that you reverse the Ninth Circuit's decision. Thank you.
Thank you. Counsel?
Yes, Your Honor. Madam Chief Justice, and may it please the court. My name is William Allred, and this evening I represent the respondent, Omar Sharrieff Gay. We are here today because two rogue psychologists claim that they have a free pass whenever they wish to racially discriminate against parole candidates in their evaluations. That cannot be right. And that's not how the law of absolute immunity works either. And that's for three reasons. The first is because when the parole psychologists questioned Mr. Gay, they were functionally comparable to police investigators, not to judges. The second is because on these facts, it would be bad public policy to extend absolute immunity to these petitioners. And the third is because in Antoine, this court established a strong presumption against new extensions of absolute immunity. And on these facts, that presumption has not been overcome. I'll first discuss the common law analog.
Well, let's discuss whether these are rogue probation officers as a first line of analysis. What should the court be doing to protect that sort of missive from being applied to individuals who are called upon by the court to provide a function? And isn't that the very reason that they're asking for and demanding the court to give them qualified immunity? Because once they are labeled, even if qualified immunity later protects them, they still bear that label.
Yes, Your Honor. The reason that these petitioners should be satisfied with qualified immunity is because the bar for qualified immunity is low. It's an obligation to act in good faith and to respect fundamental constitutional rights. Furthermore, we have findings of fact from the district court that take the vexatious litigation policy argument off the table. I quote that the psychologists offer no evidence of any significant volume of vexatious and burdensome actions against them. Therefore, that particular policy argument cannot be entertained on these facts, and we must proceed on the assumption that qualified immunity is sufficient.
Well, you understand that if there's absolute immunity for probation officers in this function, for psychologists in this function, they would never be sued by any lawyer worth his or her salt. And so there would never be any burden on the psychologists at all.
That's correct. If they were covered by absolute immunity, then there would be no burden, and that would lead to injustices like the facts in front of us today.
Is this an all or nothing argument from your perspective? In other words, can we look at the functions that were exercised by the psychologists in this case in steps? So at step one, they were investigating, they were performing the interview, they were gathering facts, and all of that, eventually culminated in a risk assessment, a recommendation that was provided to the decision maker. If we view it in that way, what is the result? And should we view it in that way? Should we parcel it out so that maybe the psychologists are entitled to immunity at one stage but not the other?
Your Honor, we should parcel it out that way, but at both stages, they are not entitled to absolute immunity. Beginning in the investigative stage, when we apply the Antoine test of identifying the common law counterpart to the immunity that's being sought, in the investigative stage, when they're questioning, they're doing something that looks very much like a police interrogation. As they conduct their interrogation, they make a racist comment that baits a confrontational response and turns the tenor of the interview negative, which causes a legal injury. In the investigative function, we have a self-contained cause of action. Now, when we move on to the compilation of the CRA report and the risk assessment, we do have colorable arguments for analogs to witness immunity and judicial immunity, but each of those arguments fails for different reasons. On the witness immunity question, the analog fails because, yes, substantively, they are providing information to a court that helps a court make a decision. But procedurally, when a witness swears in, takes the stand, and subjects him or herself to perjury penalties for dishonesty, we have procedural protections for the accused that are not analogous to anything that appears before us on the facts today. That is why the analogy to witness immunity fails, Your Honor. As far as the analogy to judicial immunity, this court in Antoine said that the touchstone for a judicial analogy is, and I quote, resolving disputes between parties or authoritatively adjudicating private rights.
So you would agree that the parole board, the review board, has absolute immunity?
Absolutely, Your Honor.
No pun intended.
No pun intended.
What do you think are the adverse consequences if we decline to recognize absolute immunity here?
Your Honor, if we make a narrow holding on these facts that these petitioners on these facts are not entitled to absolute immunity, we don't believe that there are adverse consequences. This does not prevent future petitioners on different sets of facts from asserting that their functions are burdened by qualified rather than absolute immunity. And if a petitioner were to come forth with different findings of fact from the district court to the extent that there was a significant risk of vexatious litigation keeping them from doing their jobs, then by making a narrow holding today, this court doesn't hamper its freedom of maneuver to do a different thing later on different facts tomorrow. I don't think that
When you say different facts, do you mean if there at a later point in time was a record of vexatious litigation that maybe the court should take a different view? We have to wait and see?
That's correct, Your Honor. I think the different facts I refer to would be a finding of fact that there was a risk of burdensome litigation keeping them from doing their jobs. That's not what we see here, nor do we see the analogs to the Antoine test satisfied. So if both of those tests were satisfied on different sets of facts, then the court should hold differently. But that's not what we're looking at here, Your Honor.
Why should that matter? I mean, why should the risk of litigation or the risk that their conduct would be chilled, why should that matter if the test is really just a functional test? I mean, that's what you've argued. If it's a functional test and we determine that the function in this case is not entitled to absolute immunity, then why would that change, or could that change in a future case, just depending on, testimony from the psychologist saying, well, I couldn't do my job because the risk of litigation was just too great?
Your Honor, I agree that it's wise to separate those two things. I think the policy argument by itself would never be sufficient. It is difficult, on the other hand, to imagine that the Antoine test of an analog to a common law immunity, it's difficult to imagine that black letter test being satisfied in the policy concern also not favoring absolute immunity.
Do you think that judges are entitled to absolute immunity in every aspect of what they do? Or are you suggesting that if we decline to grant absolute immunity here because you're parsing out the various behaviors that were engaged in, that judges too would be subject to risking losing absolute immunity?
No, Your Honor, a holding in this case would not compromise judicial immunity for judges. Judges are the paradigmatic analogy to common law judges. Therefore, in the case of a judge, the Antoine test is easily satisfied. Now, maybe that looks a little bit different when the judge is off the clock acting as a private citizen, but I don't understand that to be your question.
But you would agree that, mechanical tasks that are performed by the judge, him or herself, in the course of their judicial duties are entitled to absolute immunity?
Yes, Your Honor, I do agree.
So you would agree that the Fort versus, I believe it was Washington case that the Ninth Circuit decided that involved, scheduling something, kind of a ministerial task, but that was performed by the decision maker itself, is a function that is protected by absolute immunity?
Yes, Your Honor, because it passes the Antoine test of being analogous to what a judge does herself when she manages her own docket, which is a common law function that is protected by absolute immunity.
Let's say the INS is standing at the front of the courthouse waiting for an illegal immigrant, and the judge is adjudicating that person's rights, and the judge decides to take that person out the back door so they won't encounter the INS officials at the front of the courthouse. Would that judge, who was doing that in the course of this litigation and as part of the overall administrative function of the judge, be entitled to absolute immunity once we decide, in your case, in your favor, that these psychologists are not?
Your Honor, if it were a judicial administrative function, then no, they would not be covered. Now, I'm relying there on this court's verbiage in Antoine, in which this court hypothesized that when the judges are acting in their judicial capacity, they are covered, but in their administrative capacity, they are not. I am not prepared now to draw a line between a judge's judicial and a judge's administrative capacity. Your Honors are much better equipped to do that than I am, but that is correct, Your Honor. I'll next proceed to discuss the integral and discretionary tests, which the petitioners have relied upon to support their case. The pre-Antoine case law contains multiple tests based on whether the function is integral and whether the function is discretionary. And the petitioner has made the argument that when you combine those two factors into a conjunctive test, in essence, if it is integral and it is discretionary, then it is covered by a qualified immunity. However, that test fails for two reasons. The first is because it's overbroad, and the second is because it's just not what the court said to do in Antoine. As far as the overbroad component of that conjunctive hypothetical test, it would cover police officers who we all understand are covered by qualified rather than absolute immunity. Police officers perform functions that are integral to the judicial process. It's very difficult to imagine a judicial system functioning.
Are you prepared for this court to overrule Antoine and just say that it should combine the factors and require it to both be functional and integral in order to provide for immunity?
Your Honor, to clarify the question, is your proposition functional plus integral plus the Antoine test?
That's right.
Your Honor, we would require additional findings of fact to decide whether that's a wise move or not. If we layer on additional necessary conditions to the Antoine test, then we risk reducing the scope of a judge's qualified immunity. I can imagine circumstances where a judge does something that is not integral within his or her judicial function, or where a judge does something that is not discretionary within his or her judicial function. Under that proposed test, that judge would no longer be absolutely immune for those actions. That reduction in the scope of a judge's absolute immunity is something that the district court has not provided us with findings of fact to make a good decision on in this case today.
I take Ms. Byrne's argument to be that within the functional test, one way to determine whether the task performed is functionally equivalent to that of a judge is to look at whether it requires the exercise of discretion, plus, being kind of essential to the judicial process in some way. So in that sense, it's not, it's kind of making it somewhat easier to show that it's an alternative in some ways to meeting a purely functional test. I mean, why isn't that the right way to look at it? It does seem to me that discretion should play an important role. I mean, if you think about the function of a judge, one of the core functions of a judge is to exercise his or her discretion in the process of making a decision. And if the act at issue allows the judge, is an essential part of allowing the judge to make that ultimate decision and itself involves the exercise of discretion, why doesn't that fall squarely within Antoine?
Your Honor, it doesn't fall within Antoine if it establishes a possible replacement to the Antoine test. And that's purely because of what the verbiage in Antoine says, which is that the burden for a party claiming absolute immunity is to identify the common law counterpart to the immunity being asserted. And in the case of judicial immunity, this court in Antoine said that the touchstone for such analogy is, again, resolving disputes between parties or authoritatively adjudicating private rights.
How narrowly do we need to conduct this analog inquiry? I mean, do we need to find common law support for showing that, psychologists making risk assessments are, that was protected by absolute immunity at common law? Or if not, then how much more broadly should we conduct that analysis?
Your Honor, the brilliance of Antoine is that it is flexible, to answer your question. So, for example, if you were to take these same psychologists who potentially psychologists themselves might not have a common law analog, and I do see I'm close to time. May I finish answering your question?
Yes.
Thank you. Even if the role of a psychologist in a courtroom proceeding was not analogous to the common law, they could still fit the Antoine test. For example, if they swore in as witnesses and subjected themselves to perjury penalties, or if they were empowered to authoritatively say, yes, the candidate gets parole, or no, the candidate does not, and authoritatively state the candidate's legal rights, then they would fall under Antoine. In conclusion, this court should affirm the holdings of the district court and of the Court of Appeals and not extend absolute immunity to the petitioner psychologists. Thank you.
Thank you.
May it please the court. I want to start where Your Honor left off. Your Honor is right that this court found in Imbler that when judicial immunity extends to officials other than judges, it's because their judgments are functionally comparable to that of judges in the discretion they use. Our argument is not that the psychologists here were integral and discretionary, and that's why they should receive absolute immunity. It is because they meet the functionality approach laid out in Antoine and in Imbler by this court. They function to help adjudicate rights, and they exercise discretion in doing so. To Your Honor's point about Fort v. Washington, this case is not about the title of an official. It's about the function that the official plays.
If they make no decision, they have no decisional function, aren't they at least one degree removed from the role as a judge?
Your Honor, we believe that they do make decisions. They aren't binding on the parole board, but they do decide what level of risk they see the inmate having if released. There is no evidence that the parole board looks at anything other than that risk assessment. These psychologists are hired by the parole board only to make that risk assessment.
If the parole board looked at more than one set of criteria, would that change your view?
No, Your Honor. We believe that the decision of the psychologist is integral to the parole board as stated by the parole board. So even if they did review other things, that wouldn't negate this point. However, we think because there's no evidence they look at anything else, that shows how closely tied the psychologist's evaluation is to the adjudication of prisoners' rights. To respondents' point that a lack of vexatious litigation means we shouldn't grant absolute immunity, a lack of evidence of vexation litigation does not mean that we should allow the potential of vexatious litigation to cloud the objective decisions of psychologists making these risk assessments. Psychologists hand the parole board a form, and the parole board all but signs it based on the psychologist's evaluation of how violent an inmate is.
So you don't think that if the parole board made a decision to incarcerate an individual based upon its discretionary authority, that the psychologist would be here saying, we shouldn't be sued along with the parole board. We didn't make this decision. It was the parole board that made the decision. You think they would stand and fess up and say, yes, we made the decision right along with the parole board?
Yes, Your Honor, we believe that the psychologists here view themselves as the gate between the prisoner and the parole board, and it is the psychologist's evaluation that directly lead to the parole board's decision. Thus, this court should reverse the Ninth Circuit's decision and hold psychologists are absolutely immune for this discretionary function.
I believe my colleague had a burning question, did you?
So if this is not all or nothing, I'll ask you the same question that I asked opposing counsel. How does this case come out for you? If we look at the interview part of the psychologist's function separately from actually making the risk assessment and submitting that to the court?
Your Honor, we don't think we can separate the two. It is the evaluation of the inmate during the interview when the psychologists use their education and experience to make that risk assessment. So here, we can't separate the interview from the risk assessment. The evaluation during the interview is what directly leads to that assessment. Thank you.
Thank you.
All rise.
Well, there should be an applause for these two candidates.
You may be seated. The judges will be back shortly after deliberation. They'll be here soon. All rise.
Be seated, please. The court has deliberated in this matter and determined that on this record, it will, drum roll, grant the petitioner's reliefs. This was very, very, very close. We thought both of you did a fantastic job. You were both very professional, very responsive. We looked at the rubric. We couldn't decide on the basis of the rubric because you all did everything you were supposed to do in the context of the directions you've been given. I will say I thought that the respondent came out a little too hard on the rogue psychologist. I was all prepared to grant relief until I thought this poor psychologist out there doing this work and this person labeled them as rogue and they don't have immunity. And to protect against that, we need to keep them from being sued. But I thought you held your ground well when asked those questions and was very respectful. And I thought the respondent, on the other hand, came out pretty hard on a wrong record about people not having made decisions, people having made decisions, because I thought that the testimony in the record showed that the psychologists did not believe that they made decisions. And so I thought that was a little off-putting in terms of the substance, but in terms of the style and the delivery and the work and the knowledge of the case and the knowledge of the case law, I thought it was very well done.
Well, I agree. Very close call. You all were exceptional. I was sharing with some students I had breakfast with that my Hardt Cup performance, my 1L year, was nothing of this caliber. So great job to both of you. Can tell you spent a lot of time preparing, and both for style, but also on the substance. I'll start with Petitioner and just offer a few thoughts and then move on to Respondent. I thought you did a really nice job of arguing that this falls squarely within Antoine. I actually expected that you would be arguing for some modification of the Antoine test to really fit this, but you kind of surprised me by making a very convincing argument that, this does fall, if you just look at the unmodified Antoine standard, that this satisfies that test. So great job on that. On the style, I thought you transitioned very smoothly. There were no awkward pauses. You got back to your points, but also were very engaged and conversational. So it never seemed like you viewed our questions as interruptions so that you could get back to your points. It was a seamless way of transitioning. And I thought your rebuttal was especially strong, that you were able to, rather than, have kind of prepared points that you wanted to make, that you were able to be kind of nimble and respond to things that we were asking about and arguments the respondent had made. So great job on that. I thought you were really excellent on the substance. I think you were very wise to focus on the kind of historical common law analog test. I mean, that's one of the strongest points for you. I think as you could probably tell by my questions, the argument that I didn't find as convincing was your kind of quick turn to the policy arguments, because I thought you actually had very strong arguments just based on the test itself. But I also understand why you did that, because I think there are, anytime you talk about immunity issues, the policy arguments are always in the background. So I didn't fault you for doing that, but I think you did just all around a terrific job. You also had smooth presentation, great transitions, good. I could tell that you really knew the material and had studied the cases and were able to draw from that in responding to our questions. So terrific job to both of you. Congratulations.
Well, I'll just offer a few more, but it's really just echoing what my colleagues have said. I mean, you both were fantastic. I mean, you really were. I would just do what you did today in the future. And maybe, if you have any questions for us, but I think stylistically, you both have different styles, and I think you have to, stay true to your own style, but they were both equally good. William, you're very smooth. You just have a kind of a way, and while still being very organized and very responsive. And Casey, you kind of remind me more of like how I am, which is, you're like maybe not always you were smooth, but just very methodical, very organized, very responsive, so I think you have to go with what style works best. But at the end of the day, you both were extremely composed, respectful, didn't really fumble at all, knew your materials very, very well. And you just did a really excellent job. So it's just a pleasure. It's amazing as one else that you've achieved this level of confidence and eloquence, and just continue to work on the things that you didn't seem as if you were nervous or uncertain about things, but you probably know best internally if you were. And those are things just to be mindful of, and just continue to grow, because you have so much time to grow as law students and then as lawyers.
Well, you made me nervous, which is really hard to do. And I think I asked Ms. Byrne a dumb question, and she didn't say that's a dumb question. She just answered the question so that I could realize it was a dumb question. So I appreciate the smoothness with which you dealt with me.
And I'll just add, we've all, I think, heard from a number of people that the pool of talent in this 1L class is deep, and it's really something to behold. So I'll just I know there are probably a lot of folks in this room that competed earlier in the tournament, so congratulations to all of you. I'm really excited to see what's ahead. Sounds like this is, not that every class is not great, every class is great, but it sounds like this 1L class is really special, so congratulations.